Hello, I'm Terry Kelly, Director of Representation and Member Services of the Law Society of Ireland. This is one of a series of videos that provides information for solicitors about buying, selling, merging and closing a legal practice. If you have questions or need additional support from the Law Society's Small Practice Support team, please contact us using the details at the end of the video.
Welcome to information on merging legal practices, a Law Society Small Practice Support video that is one in a series providing information for solicitors on buying, selling, merging and closing small practices. I'm Keith O'Malley of Law Society Small Practice Support Service. When legal firms merge, at least one of the former firms will need to close. Any sole practitioner firm involved will have to close. So, quite often in merger situations, a number of firms might need to close with practitioners involved working thereafter in a partnership firm that is either new or already established. This video outlines regulations that must be complied with in a merger situation. Let's start with what information needs to be notified to Law Society of Ireland. As soon as any practice purchase, sale, merger happens, the Law Society needs to be sent a formal notification so that its records can be updated. The following information is required: the date on which the firm is being sold or transferred, clarification whether all files, including closed ones, are being sold transferred to one firm. If files are being distributed among various firms, details relating to the distribution need to be outlined in the notification. Confirmation that all clients' monies are being transferred as part of the sale transfer. Clients of the firm that are being subsumed need to be notified promptly of what is happening. It is then a matter for each client to decide whether to authorize the partnership to continue in the provision of legal services or to advise that they would prefer to instruct a new solicitor. Law Society guidelines note that it would not be proper for a new firm to take over the affairs of any client, including holding client money and files, without the client concerned first providing written authorization to do so. It is also noted that when appropriate, notification letters sent to clients should note any credit amount outstanding on their account. Law Society guidelines provide instructions on the release of undertakings following a purchase or sale of a practice, and these guidelines apply in mergers. There are provisions in the solicitor's accounts regulations regarding the transfer of clients' monies as part of a practice purchase. Depending on how a merger was organised, it may be necessary to issue an appropriate notice of change of solicitor to the courts and opposite parties in disputes. If any part of the merger, some files have been transferred to another practicing solicitor or solicitors, the Law Society must be identified about the identity of that practicing solicitor and whoever has access to the files. The Law Society should be informed that the partnership is going to be a succeeding practice, and written confirmation of this should be provided to the Society from both the ceasing practices and the partnership that is operating the merged practice. If any of the former firms intend to run runoff cover, they need to contact DWF Claims Ireland 60 days ahead. For any firms involved in the merger that are being closed, those firms must execute a cessation and a closing accountant's report reflecting nil balances on the client account for each firm that has ceased must be submitted to the Law Society within 2 months of the cessation date. The balance on the client accounts included in the closing accountant's report should be nil. We have come to the end of this video. There are several other videos in this series that deal with the wide-ranging aspects of buying, selling, closing small practices. I hope they're of assistance to you. Bye.